Whitley, welcome. Thank you very much for agreeing to do this podcast with me. As you know, I'm working on a book for a large UK publishing house. The working title of the book is Fraud Investigation and Forensic Accounting in the Real World. And I'm using my own investigation experiences from the past 40 years to illustrate the concepts that are presented in the book. So it's very unique in that way. It's not, an academic or theoretical text. It contains very practical information based on the work that I've actually done over the years. And, I have had the privilege of working with lawyers like yourself on these investigations and have learned a great deal. And the reason I wanted you to be here today is learned a great deal and developed professionally because of working with lawyers like you. And just by way of introduction, I met Joe Whitley in the early 1990s when he moved to Atlanta after serving as the United States Attorney for the Middle District of Georgia. Prior to that, Joe was a state prosecutor in Columbus, Georgia. He worked in the private sector here when I first met him, but then went on to become the U.S. Attorney for the Middle District, or for the Northern District of Georgia, which is headquartered in Atlanta. Following that, Joe came back to the private sector and worked together on some very interesting investigations when he came back. But then he was called on by his government to serve again, and went to Washington to serve as the very first General Counsel for Homeland Security. His government service and service to our country stretches over many years. I think it has defined his career and his professional life. He certainly has maintained a stellar reputation and is highly regarded here and in many places around the world. The one thing that I left out, and I think it's very important, is that Joe also served as an assistant attorney general under Dick Thornburgh when Dick Thornburgh was the Attorney General of the United States. I wanted to mention that because in that role, one of the things that Attorney General Thornburgh tasked Joe with was to go around the world and negotiate legal treaties, mutual legal assistance treaties with other countries, between other countries in the United States. And Joe literally had to, travel the world to get that done, but he did, and it made a huge difference in the efficiency and the effectiveness in our government's ability to prosecute its legal interests in other countries, and for our citizens, of course. I've had the privilege of knowing Joe now for, gosh, I guess it's almost 30 years at this point. And it's been a wonderful relationship, and that's why he was one of the very first people I invited to do these podcasts, because I very much wanted him to be a part of this, and I'm very grateful for him agreeing to give us the time today, and want him to know it's been a great honor working with him, and I look forward to our working together in the future. I have selected a case that I wanted us to talk about because it touches on areas in which Joe has a particular expertise based upon his professional career. And this is a case, it's a very recent case, but it's a case that was the subject of a Department of Justice press release on July 23rd of this year. And the headline is, United States files complaint to forfeit more than $2.37 million from companies accused of laundering funds to benefit sanctioned North Korean entities. Because the United States has filed a complaint to forfeit these funds. The four companies allegedly were part of a scheme to launder payments to subsequently sanctioned entities, to include Velmore Management, which the Treasury Department sanctioned for procuring Russian petroleum products from North Korea, Dandong Juchung Metallic Material Company, which the Treasury Department sanctioned for purchasing coal from North Korea, and then in turn laundering the proceeds of those sales to purchase items for North Korea, including nuclear missile components, multiple cover branches of North Korea's foreign trade bank, which the Treasury Department sanctioned for facilitating transactions on behalf of actors linked to North Korea's proliferation network. The Justice Department goes on to say, this complaint illustrates how a global money laundering network coordinates with front companies to move North Korean money through the United States and violate sanctions imposed by our government on North Korea, said Acting U.S. Attorney Sherwin. This case demonstrates that we will use all tools in our threat finance unit's portfolio to target companies that harm U.S. national security, regardless of where they are doing business. The FBI, along with our domestic and international partners, will continue to prioritize and dedicate the necessary resources to investigate and combat those who are assisting North Korea in evading sanctions by providing illegal access to the U.S. financial system contrary to our national security interests. Wow, that sounds really bad. It sounds like everybody's guilty. I guess that's the end of the podcast. Thanks, Joe. I don't guess there's anything for us to talk about. I'm kidding. They always sound like that. And Joe and I are the people who are hired by, often by people who are the subject of these press releases. And one thing I can truly say, having done this over 40 years, there's always two sides to every story. And so with that, Joe, I'd like to ask you a few questions about this case. First of all, let's say you're representing the defendants in this case, and let's assume for a moment that their interests are aligned, and so there's not conflicts of interest, because I want you to be able to move between the parties fluidly in order to talk about how you would handle this case. But what problems do they have? You know, $2.7 million, that doesn't sound like a lot of money to me.
No, it's not a lot, Bill, and I guess I should say I'm anxiously awaiting the publication of your book, so I'm going to go buy a copy right away when this gets printed. So I can't think of anybody better to be writing a book on the subject of investigations than you, and certainly you've covered in your career a wide span of investigations that will be exemplary to people who obtain your book, and I look forward to doing that myself. I suppose looking at this case, and to your point, although each of us would like to have $2.37 million immediately in our bank account, it's a relatively small amount of money, considering the scope of other cases where we see huge sums of money being seized in the hundreds of millions of dollars sometimes, or hundreds of millions of dollars in fines and penalties. In this situation, I think what you see is sort of the tip of the iceberg, really the beginning of a case. And under U.S. asset forfeiture law, there are two types of forfeiture. There's civil forfeiture, which is what this represents, civil complaint. And then you have the underlying criminal case, which there is a criminal case here going on, I can assure you, based on the facts of this particular press release. against individuals and against these entities, which and from which there'll be even bigger fines and penalties and more money that might become subject to seizure through the criminal case. But anyway, I would comment on this as this is the first bird of spring, so to speak. More to come in this case, and what you have immediately though is a PR nightmare in terms of what's happening. It's just this will be spread all over the Bloomberg, the financial news. But you do have here a parallel criminal investigation going on, I can assure you, and this broad exposure that all of these companies and entities have. And the burden of proof is a little lower, certainly in civil matters or civil action. So this was the best way to gum up the works, so to speak. Once something like this happens, the ability of these companies and businesses to do business around the world becomes doubtful, because no one wants to do business with anyone who's subject to a civil forfeiture action dealing with allegations of money laundering. So it has a business angle, a public relations angle. There's certainly a deeper look that someone like yourself would want to take, looking behind the curtain, so to speak, and finding out what's really going on here.
That makes sense, and it's a nice segue into my next question. What would you do to gain an understanding of the exact nature of their problems? And what I'm thinking about here is there a way to interact with the Justice Department to learn more about what exactly they have and what's at stake here?
Well, this is not like the antitrust area where the first person in the door may get immunity or something along those lines under U.S. antitrust laws. But I do think the version of that is, again, being proactive. I in my experience over the years, it's helped me to not be immediately combative with the government. And depending on the individual lawyer, sometimes the approach is to hold a press conference and say that your client is completely guiltless and the government's going to have to prove it, and that's the way it goes. I think when you do that, though, you preempt other options you have, which is coming in really, Bill, for a softer landing. And I think it's important to be deferential to Assistant Attorney General John Demers, who's head of the National Security Division, our acting U.S. Attorney Sherwin in this particular example, and Homeland Security investigations. There are at least those three components at work here. I contemplate in this particular factual scenario that I would probably go to the attorneys in this matter. I wouldn't go to agencies. In other words, not that there's not a lot to be accomplished by being in touch with those agencies, but I would go to the decision makers in terms of prosecution. And that would be the local United States Attorney in the District of Columbia, Mr. Sherwin, or Mr. Demers at DOJ, who's head of the National Security Division. And I think by doing that, you're going in and saying, my client has retained me. My client has asked me to ascertain what occurred here. Our initial appreciation of this is we don't really understand why we're in your sites. Can we have a proffer, almost a reverse proffer, for some understanding of the circumstances we find ourselves in? We want, and thematically, we want to cooperate with you. We want to find a way to assess the problem, because I think as a practical matter, again, we haven't really defined who I'm representing, but let's say for the purpose of these comments, I'm representing the corporation. There's not a lot to be gained under the corporate sentencing guidelines, and other laws, securities and exchange laws and regulations from doing anything other than what I've just described, depending on which entity you represent. So I'm talking about the corporate entity when I'm saying what I've just said.
And let's say, to narrow it just a little bit,
yeah.
Because this case unfortunately includes the North Korean Foreign Trade Bank. So let's say you do have a conflict with them, they're off the table, but you're representing Velmer Management, the company that allegedly purchased Russian petroleum on behalf of North Korea. So them standing alone.
Right.
And because you're representing the company says to you, we have no idea what happened here. We are clueless about this. We certainly did not sanction any of these kinds of activities. How does that change your thinking about it?
I think that scenario is one that's familiar to me, Bill, because I represented someone in a similar case, a corporate entity that was violating the Iranian sanctions. I strongly believe in this situation, and that, assuming now the facts are critical, the one thing we can't change, I guess we're entitled to assess the matter, but we can't change the facts. But I would want to ask the government for a window where I would, and tell the client, I'd like to do an internal investigation, a reactive internal investigation. I've let the government know I was doing this too, so there wouldn't be any concern that I'm somehow obliterating or obscuring information. But I would want to find out exactly who, and Velmer, who exactly was the decision maker on this decision to deal with this illegally and violate the North Korean sanctions. I think, again, depending on the size of the company, there could be an argument, again, and we don't know in this circumstance, but I'll just use this. I've seen this happen, and it's not made up. The rogue actor situation, where you have someone at Velmer who is at a lower level receiving compensation, perhaps outside of the compensation from the company, in other words, bribes of some kind, to bend or break the law about the North Korean sanctions. And so I think that there should have, the government will say, well, there were red flags. You should have known this about your employee. Sometimes damage control is what you're doing, but I do think getting a handle on what laws did we violate? Obviously the International Emergency Economic Powers Act, IEPA, is one that comes to mind in this situation, and others. We don't want to have this go down the trail to us being put on the SDN list, for example, with OFAC, right, the specifically designated nationals or entities. So we have a real interest in breaking through early and trying to find out what's going on here, and being a cooperator, if you will, Bill, with the government. And obviously this is kind of a cold chill feeling for the employees of the company, but I think that preemptive corporate internal investigation may well disclose that the company did follow the steps that it should have followed, but there were individuals in the company who broke the law, and we'd like to cooperate in helping with that. Obviously, it would be good if Velmer had in place a corporate integrity agreement of some kind or compliance plan, but obviously we would agree as part of any kind of resolution with the government to make that more robust, have reporting obligations on our part with the government, so we can position ourselves. Positioning is a word I really don't like, but so much of what I do in my practice is positioning. Can I position my client for a favorable outcome? And I'm always thinking about this is kind of how I'm centered and how I look at things. I can't will it to happen. I really have to work to that objective. But how can I position my client, Bill, with your help? Obviously, someone like you is going to be side by side with me as I do the investigation.
And that's critically important. And you just hit on something that I see all the time, and that is that these incidents are not transactional. They, in fact, really literally affect the entity's ability to continue in business over the long term. And so, just to follow on your point, if there was a way to reach an amicable, agreement with the government that would allow them to continue to do business, albeit there was an additional expense to that, as well as this forfeiture piece, and perhaps helping them in their prosecution of the rogue actor who you mentioned earlier. That's a win. That's a huge win, because the alternative, you mentioned the SDN list. The alternative is I'm out of business. I'm done. I don't have a way to continue to operate.
Right. I agree, Bill. I think this has happened in a case recently with me in a domestic U.S. case, but a case in point is our client had problems dealing with immigration laws and H-1B visas, without getting into specifics. But in this hypothetical, I'll say, the government wanted X amount of money back in the way of fines and penalties. The best way for us to achieve our ability to pay those fines and penalties was for the government not to kill the goose, if you will, with the golden egg metaphor.
Right.
For them, if we could show them that we were going to henceforth be achieving a legally compliant program, the government had a vested interest in our maintaining our financial viability. Instead of sinking the entire effort for the company could continue in business during a period of transition toward the payment of the fine. So, and that's, I don't believe, an aberrant situation. I do think that the realistic component of this is how do you achieve the government's objective, and at the same time, how do you achieve your objective? So it's a win-win outcome.
And let's say, Joe, you do the internal investigation you were talking about earlier, but the rogue actor actually still has significant responsibilities and authorities as the investigation proceeds, but realizes that you're getting closer to the truth, and begins to do things to prevent you from collecting the evidence to prove that truth. What do you do in that circumstance? How do you advise the client in that circumstance?
So this is a sort of the Robert Frost poem, two roads diverged in the woods, and we want to take the one less traveled, and that will make all the difference. And I think what I would want to do is separate the employee or executive from further duties at the company. And there may be provisions in the corporate bylaws for the retention of counsel for the individual. So because at that point we have a conflict with that individual, we can't really advise him or consult him going forward because he is in a different status. I mean, there's a lot more here to talk about that issue in terms of conflicts of interest. But I would want to continue to maintain access to this individual through his or her counsel. But I think the imagery for the government is so much more preferred if that person who is deemed to be the malefactor is now no longer on the premises, so to speak. In other words, in a figurative sense, he or she is sidelined, and then that investigation can go forward. I think it's a difficult situation because this individual, likely in this hypothetical we're talking about, is a friend of many people for many years, possibly. But the corporate officers have an obligation to the corporate entity, and they have fiduciary obligations that further make this more complex. With the Securities and Exchange Commission, and if it's publicly traded, there are all kinds of things that are going along with that phenomenon that require there to be the duty to the shareholders of the corporation is of the utmost importance. And I think, regrettably, that individual needs to be separated from the company.
Well, I think that's an excellent point. You also hit on another excellent point, which is the denial piece. If I had, I've been doing this for almost 40 years now, but if I had $1 for every time I eventually identify who the bad actor is, right, and present the findings to the client, and hear in response to that, that's impossible.
Right. Right.
I could have retired a long time ago.
Yes. Yes.
And I don't know the psychological science behind this, and certainly am not trained in that area, couldn't speak to it, except from observation. But what I have observed is it's almost like people feel like it's impossible, because how could I work with every day and have had, lunch with and befriended a person who is a criminal? How could that, how could that be? What does that say about me? And the answer to that is it says nothing. It says you're a normal human being. And in my experience, I've run across probably 3 sociopaths in 40 years. But other than that, what I've run across are often good people who sometimes do bad things. And so they are, they're very likable. They're, they can be very charming. They can be, very pleasant to work with and to interact with. And there's no reason why you wouldn't befriend a person like that. And sometimes, for reasons that you may never be able to understand, they just do bad things. And sometimes they get caught at it. But I hear that point that you made, I think, is so important, that that sense of that could be, that's not possible.
Yes, I do think, just to comment on that, there's a English television show called Doc Martin, and Martin Ellingham, Martin Clunas plays the lead in that show, and it's still on the air in England. And Martin Clunas plays this doctor who provides patients with really bad news sometimes. And a little bit like that for us as lawyers and accountants, consultants doing these investigations. People don't want to hear the bad news, and in this portrayal on television, Doc Martin delivers really bad news, and oftentimes the individual patient just ignores it and continues with their bad conduct, and then they'll end up back in front of Doc Martin. He'll say, "I told you to take this medicine, you didn't take it." And I do believe that Bill, it's a real challenge to get. Over the years, I have dealt with some pathological people who lied to me, just straight out, face to face, lied to me, and then there's always the moment of truth later at some point, either after they've been convicted or before. and they'll in a moment of almost like, I'm not a Catholic priest, but almost like a confessional moment, coming in and saying, I've sinned, I really have lied to you all along. Now I'm telling you the truth. And that's a bad moment, because there's nothing worse than telling me something is not accurate, because unlike Doc Martin, I've got to carry that message to somebody else. The message to Doc Martin is just to him, but you and I are going to be sitting down in a room filled with federal agents, filled with prosecutors, and we're going to be telling them a story, and I won't use the word, but it's bull and then a word right after it.
Right.
We're going to be telling them a word that is bull blank, and that's not where you want to be, because those agents and prosecutors know that, well, this guy is hoodwinked Joe, he's hoodwinked Bill, and so that individual is not only dead, he's buried. It's just not a good thing. So I do have a come to God type discussion with individuals at the beginning of a representation, saying, I know that your instincts are to lie to me about what happened, but it really is going to help you if you're truthful with me. And I usually do it with you or someone else with me. I have to have somebody as a witness to this. Right. And anyway, sorry to go on so much, but
no, I think that makes another great point, which is sometimes these things, you talked about people who will lie even when it would be very easy just to tell the truth. And sometimes that can happen very innocently. I was working on a large internal investigation of a public company with one of your colleagues. And they had gotten a grand jury subpoena that covered all of their electronic information, the email server and all of that, as well as any backups for all of their, data processing systems. And we had gone through this very, very exhaustive process with the chief information officer to make sure that we complied with that subpoena. And your colleague, who you know very well, signs off. It says that that's it. We've given you all that we have, and then goes back to his office. I continue to do my work, and about 2 days later, 3 days later, the chief information officer comes in to the conference room I'm working in, and he says, "Can I see you for a minute?" And I said, "Sure." So he said, "Would you mind coming to my office?" "No, not at all." So I go into his office, and he says, "Remember we got that grand jury subpoena? Uh-huh. And you remember that we went through the exhaustive process to turn over all that electronic information to the government?" "Uh-huh, I do remember that." He said, "There's something that I didn't tell you." He said, "About 5 years ago, we changed our document retention policy to shorten it." And he said, I was not comfortable with that. And as a result, I was always afraid that they'd need some piece of information that would have been destroyed under that policy. And so I just wasn't comfortable. And so I kept my own backups. And he's opening, he's got these lateral file cabinets. He's opening these things, and they are filled with these backup tapes, hundreds of them.
Oh my God.
Yeah. So I called your colleague and I said, "Rick, I have some very, very bad news for you."
Oh my.
And of course the guy could have simply said to us,
right,
I have these other backups, and
yes.
and didn't, for reasons that I don't think anybody at the company would have been upset. I mean, I think they would have realized,
right.
Well, he's old Harry. He's just really cautious. But things like that, and it really, I'm laughing about it now, but it created a very, very difficult situation with the government.
Right.
And anything like you talked about that earlier, that one of the most important things is having a respectful relationship with the government and not violating the government's trust in that relationship. Could you talk about that just a little bit more about why that's so very, very important in the difference that can make?
Well, and I'll just a bit free associate a little bit based on your story. But I guess some benefits of being in a role where you're seen as an honest broker, one of the things that I believe you get out of that is the government will try to help you. I mean, it's just human nature. If they feel like in that certain circumstance you're talking about, they won't hold it against you that happened about the documents being in the file cabinets. They'll hold it against your client.
Yeah.
And so what I'm trying to do is have the government perceive me as the entity that they're dealing with, not the client, as much as I possibly can. And it's no sleight of hand or anything like that, but I've had situations arise when I've had my client debriefed. They're in front of the government, no sodium pentothal involved and no shock involved, but they're just sitting there, drinking coffee eye to eye with the government and answering questions. And then the government has asked for a sidebar with me outside the room away from my client, and wherein they will tell me that John or Mary is not telling us the truth. They know more about all of these things. So
they trust you.
They trust me, right? Yeah. They trust me to share that information with me, and it does two things. One, it helps me certainly that they did that, but also helps them because the moving my client into a cooperator or someone who's going to get a mitigated treatment from the government, that occurs more likely in that situation where I don't, and it really is disappointing when that happens, but nonetheless, the government is sort of positioned in a way that they see you. And again, this can't happen everywhere. For example, if I were to have a case in Spokane or Tucson or wherever, and I have had cases in those places, I am always, Bill, going to be retaining someone who has credibility with a local United States attorney.
Yeah.
Naturally, today with social media and Google and Wikipedia and all that, I can rest assured that I will be looking and trying to find out more about the person I'm going to be sitting across the table from. But the government probably has called, if it's you or me, they probably called the U.S. Attorney's Office in Atlanta and said, Bill Jennings is coming in to see me tomorrow with Joe Whitley. What can you tell me about these two gentlemen? And that word of mouth reputation is so important that we were talking about earlier. I'm a little bit field from your question, but I do think
it's an important insight.
But so much of this, I mean, with, for example, with John Demers, who's a very fine lawyer who's head of the National Security Division at Maine Justice. He's someone that I've had conversations with John on the phone, for example. He knows me by reputation, and I think highly of him. But I don't think I've ever had the pleasure of meeting John one-on-one. So right. I still think, that's a situation where I'd want to do some diligence on him. And the U.S. Attorney in D.C., I probably have one degree of separation knowing him. And also from Homeland, I would know people there. So I would want to not do anything untoward about trying to find out information about who I'm meeting with, but I'd want to make sure that I'm coming in, the coordinates on my landing, if you will.
Right.
And you as a pilot would know this, making sure I'm landing at the right airport with my presentation. I don't want to go, well, this is what I do, and when I'm in San Francisco, I want to do it that same way in New York. Well, the rules are very different in different offices, U.S. attorneys' offices, and
Right.
how they treat cooperation, and whether or not I can receive some degree of protection from my presentation, that sort of thing.
You know, I almost did that one time. I was flying at the time. I had a Piper Aztec, which is a light twin, and I flew it from here to Miami. And I wanted to land at an airport north of Miami called Plantation. But there's an airport next to it that's a little bit south of it, that's North Hollywood Airport. And I got my landing clearance from Plantation. I'm on short final, and the guy at Plantation calls me and says,
Where are you?
yeah, he says, you know, you're, because he could see me on the radar. He said, you know, you're landing at North Hollywood. We're one airport over.
Oh, boy. Well, that's a chilling moment.
Yeah. So
well,
he
that's
was nice about it, and
yeah,
vectors
well,
around.
radar is such a great thing. Anyway, there's a lot more, I guess, a lot of airplane metaphors we could work into this conversation that are apropos. But a lot of this is about having the right pilot. And so I think that's kind of what we try to represent.
Exactly. And that's why I wanted to do this podcast with you. And I think that's, you know, there aren't other lawyers for a case like this who could bring that sort of unique set of relationships and experiences and techniques that you could bring. And the outcome, the point I wanted to make is the outcome could be very, very different. And of course, I've seen this firsthand. I actually remember a case that you and I had where the outcome should have been very different, but for your the esteem in which you were held by the assistant United States attorney who eventually became our deputy attorney general. And you will recall that case very well. But I still remember your unique approach to that, which worked out great for your client. I will admit I almost fell out of my chair. But you were extraordinarily candid. You didn't pull any punches. You made your case in a very compelling way, and you know, as a result, your client didn't go to jail. I mean, that's a big difference. That's a big difference in outcomes. It's one thing to lose money; it's another thing to lose your freedom. And you know, these kinds of cases, there really is no room for error. I mean, it's not, amateur hour doesn't work in these cases.
Right.
Just to kind of sum up, so let's say now for this case, we're through the internal investigation, we've identified the rogue actor, we've gotten the rogue actor out of the way, we now have an agreement with the government in which they have agreed not to indict us as the company or to otherwise criminally sanction us. What's your advice to the client? You know, how do you say to the client, look, you have just had this amazing outcome, and here's how not to throw it away. What do you tell them?
Well, I guess there's something to be said about the moment that this disclosure. Ordinarily the client, when they receive this news, they're elated. It's great news that they're not going to be prosecuted, and there's going to be, however, there will be some civil penalties, there'll be some sanctions, there will be a requirement of a corporate integrity agreement, there may be a monitor involved, a deferred prosecution agreement, or a non-prosecution agreement that will put you under scrutiny for a period of 3 years, a la Larry Thompson in the Volkswagen case, where he was monitoring that situation. I think the human memory and corporate memory is such that at the time of the actual resolution, there's a great relief that goes on in the entity or the individual that subsides over a period of time. And what seemed like a great deal at the time it entered into becomes less and less attractive as time goes along, because it has some punitive aspects to it if there's not a total declination. And I think that it's important to set some markers with the client, so the client's expectations about what the future looks like are realistic. In other words, the victory that has been declared may not be quite the victory that it's seen, later, might be seen late in later years. So the cost of compliance, the angst of having someone in your business looking over your shoulder for a period of time might be bothersome, so much so that people forget, well, we didn't get criminally prosecuted. So I think part of it for me and you too, as we communicate the outcome, which is highly favorable. And I've had this happen I've been very lucky, let's put it that way. I've been very fortunate. I do think that I think that plays a role in it. In other words, when we're each dealt cards in a card game, it's entirely arbitrary which cards we get, right? It should be, unless somebody's mishandling the deck. But from then on, once we have those cards, we have to play the cards that we're dealt, to use that metaphor, and play them as best as we possibly can. And I think that's where the skill comes in. At that point, we receive those cards as total luck, but beyond that, it's skill. And that's where we have to begin to think about, well, what are the cards held by the other players around the table, and how much should I put down? How much should I bet? And all of that, Bill, requires close communication with the client at every step of the way. And that's something I think that's lost today. I think that more and more lawyers are communicating by text or email, and then today with COVID, that may be just a consequence of that. But I do believe updating, setting down markers about where we are, mileposts, if you will, as we move along the continuum of resolving a case. That skill that you and I exhibit when we get good outcomes for our clients, and it's not always a given, is going to be best measured by the clarity with which we've communicated with our client about the steps we're taking. And I think that's something that I think your question sort of prompted me to go into a little bit more of an expansive discussion, because after all, we are in the services business. We are service. We are, in essence, brick masons.
Yeah.
We're providing a service. We're providing techniques and employing skills that we've learned over the years that will go with us when we are no longer here. But we have to build teams, and those teams are critical to our success. So the mentoring of younger people, the sharing of this book, ultimately is a great gift that you'll be giving to other people. So there's a continuing, Bill, of other Bill Jennings and other Joe Whitleys that will read it, look at it, and get some benefit from it. And it's been my pleasure to be with you today to talk about some of these issues.
Well, and I can't tell you much. I appreciate you agreeing to do it. I certainly have enjoyed it very much. I'm very honored that you've agreed to do it. And, again, I look forward to us having some more adventures down the road.
Many
Thanks
more to
very
come. Thank you so much, and all the best to all of the watchers and viewers of this very good program. Thank you for inviting me.
One thing, Joe, only if you're comfortable. What happens is when these things go out, sometimes people have questions that we haven't answered in the podcast. If you'd be comfortable with either giving them an email address or a telephone number
Sure.
that they could use to pose questions.
Well,
that's a useful thing.
I'll be delighted to do that. My email address at Baker Donelson is jwhitley@BakerDonelson, BakerDonelson.com. And that's the best way to reach me. And
Right.
I'll do my best to respond promptly. But if I don't, it's because I'm otherwise occupied trying to earn a living. And
Exactly.
but I do think that's the sweet spot of these programs, is the dialogue that we're not able to have.
Yeah.
But I look forward to speaking to some of your viewers, and I look forward to I'll be, once that book is off the printer, I'll be
Great.
buying a copy, Bill. Thanks so much.
Thanks, Joe.